And good afternoon.
Afternoon, Prof. We're just giving everyone 2 more minutes.
All right, thank you. Will somebody let me know when to start then?
Will do.
Brilliant. Thank you, Ty. Appreciate it.
Diane, if I can just quickly say, I think there's still people in the breakaway rooms that didn't realize that they have to leave the room and join the main session again.
Okay, thanks, Lisa, for that. We're just going to assess that.
Thank you.
Thank you for that. Okay, it's going to close in 30 seconds. I think people decided to engage a bit further. Hi, Prof. We've just closed the other groups, so you can start now.
Fantastic. Thank you, Ty. To all of the colleagues in the room, welcome back. We had to break away for 1.5 hours to do deep dives in parallel sessions under 4 themes: gender equality and customary marriages, where the keynote was given by Ms. Charlene May and facilitated by Dr. Ilse Mills. Impact conscious policy making, where I had to give the keynote address, and it was meant to be facilitated by Dr. Padi de Hotla. Unfortunately, he has had a family medical emergency, and our colleague Emil Fekel facilitated the dialogue graciously. Then we had human rights dimensions of Ukutwala and other girls' rights, and also moving the needle on GBV and other gender challenges in traditional communities, where the keynote was given by Advocate Joyce Maluleke and facilitated by Ms. Karen Moore. And the last one was on equality and succession or inheritance, challenges in traditional leadership and the family. The keynote was going to be given by Judge Tandaza Ndita from the Western Cape High Court and facilitated accordingly. We now just have 5 minutes presentations from the rapporteurs from these groups. May I have a rapporteur on gender equality and customary marriages, please? You have 5 minutes, dear colleague, and it's Dr. Ilse Mills. Yes, ma'am.
Thank you very much, Prof.
Mills. Yes, sorry about that.
It's not a problem. I'll answer to anything. So we had a fascinating discussion, so much more that we would have wanted more time, but the discussion centered around the problems that are experienced with regard to registration of marriages, registration of customary marriages, and the fact that women find it very difficult to, although the Recognition of Customary Marriages Act allows for a single spouse to register, so you don't have to be both spouses that have to register, as is the case in Kenya that we heard. But the problem is that women don't know how to go to the Department of Home Affairs. They can't go on their own. They feel unsafe when they want to convince family members to accompany them, especially in instances where it's a contestation of a deceased estate. You'll find quite often that it depends on whether or not family members are also beneficiaries in terms of the estate, whether or not they will be the ladies. Questions of lobola payments that are outstanding. And then at the same time, the proof of customary marriages are also a big problem. It was said that customary marriages, it's only the woman that has to be handed over. And for that reason, it's very easy for men to deny the existence of a customary marriage. And there follows many other consequences of the denial of access to property. Then we the issues that come from this lack of proper registration is that we don't have an accurate assessment of how many customary marriages are concluded every year in this country. Then the issue was also raised about the age that we still allow children to get married, which I know is now a proposal that we abolish and that we should just have a prohibition of child marriage completely. And the matter was also raised that there is no real equality of spouses, even though the Act states that the equality of both spouses should be recognized. It's still not practiced in real customary settings. Then there's also some practices. We heard from a speaker about the practice of ukuzila, which is a spousal mourning process where the widow is expected to mourn, put on garments, sit on a mattress and mourn, but there is no such expectation for a widower to do the same. So even though this is just a practice, it's not recognized in law or not legislated as such, it is still a practice that is discriminatory. We also then heard from a speaker with regard to the problem of same-sex couples being unable to marry if they are practicing a custom, because Department of Home Affairs says that you should be married in terms of the Civil Union Act. And when they want to say, but we want to practice, we have actually practiced our custom and got married in terms of that custom, then that cannot be recognized in our law. Finally, there was also proposals for a custom-based approach to culture. Ms. Debbie, I think she will be able to explain that a bit more, but that we should recognize that there are differences maybe between the cultures, the customs, but this shouldn't be something that stand in our way, that maybe this new the Green Paper published by the Department of Home Affairs and the South African Law Reform Commission's proposals for a new single marriage statute, maybe we should see this as an opportunity to start with a clean slate and completely transform our marriage laws in this country. But there are a number of problematic aspects, specifically with regard to substantive equality being reached. Thank you.
Thank you, dear colleagues. That was Dr. Liz Mills giving us a report back on gender equality and customary marriages. To save time, I am not going to summarize what she said. I'm just going to ask if there is anybody from the group who thinks the rapporteur omitted something that we should take note of, and if there's at least one person who has a burning question in the room. Okay, moving, dear colleagues, because of time, I'm going to move to the next one, which is impact conscious. Yes.
I see there's a question in chat. I think right. on this right. If I can read it for you, Prof. African customary marriage allow men to remarry while the same is true for women. How can this inequality be transformed to alien with the constitution? Maybe Bongi can put this question. I think they were typing too fast.
No, we can't allow that because this session has very limited time.
Oh, okay, sorry.
Basically, I think to Liz Mills, the question there is, maybe this is a question that can be answered by the keynote speaker in that group, who was the keynote speaker in that group was
Miss May, Charlene May
Charlene
from the
May.
Women.
So, Miss May, thank you, Doc. Are you able to provide an answer about whether the choices we made in the Recognition of Customary Marriages Act allow substantive equality between men and women, given everything that Dr. Mills has said? Ms. Charlene May, are you in the room, ma'am? Are you able to answer the question, Doc?
Well, if I read correctly, the question, I think what Bongi is asking, how can this inequality be transformed to align with the Constitution, in the sense that, so why are we allowing men to remarry, or that they can marry more than one wife, while it's not true for women? Women can't have more than one husband, if that is what Bongi is saying. And I really have to say that is something that I'm struggling with. So unfortunately, I can't give the answer to how to align, except to also recognize polyandry.
Is there anybody in the room from the Department of Justice who can quickly answer? I know we don't have a lot of time. I do know that the first draft, can you just let me sentence? The version that was submitted to the state law advisor was allowing women to also have multiple husbands if they so chose. Unfortunately, the state law advisor disagreed. The provision at the time was also recognizing the mujaji, who has multiple wives, and yeah, it's a quite a complex situation because she's a woman, but she marries other women, and then they said that's not a proper marriage. But I think that was just wrong. Do we have somebody who wants to answer this question?
Yes, I wanted to just point to, this is Mandum Dariko from the Women's Legal Center. I wanted to just point out to Section 6 of the Recognition of Customary Marriages Act that talks about equality of spouses in customary marriages. And I think within that framework, it would allow whatever benefits that are given to the male spouse should also be given to the female spouse. But there's just this ambivalence in how rights are being granted in the act, which sort of continues with some of what we were discussing in our panel. So I think within the framework of Section 6, your point that you're making about differences of rights that are given to certain people would really be the answer, in my opinion. So it should be possible for both men and women to be able to marry more spouses if they wanted. It's just the limitation is really coming from how people are interpreting patriarchal roles and patriarchal values that still continues to exist within some of the ways in which customary laws are practiced. I hope that gives some form of guidance.
That's very helpful. Mshai, do you want to just quickly tell us about Kenya? Because there has been a proposal in South Africa that women be allowed the opportunity to have multiple husbands if they so choose. And there was an outcry, weirdly, from the Christian community more than from the traditional authorities. Mshai, you're saying something about Kenya. Please take the floor, ma'am, for a minute.
Thank you. I was just commenting that came up in Kenya, and actually there are communities where this has been practiced in the past, and the Constitution allows for polyandry, if I am not corrected by Justice Mumbi or any of the other Kenyans. And so it has been something that people have had conversations on, and I think there have been 1 or 2 cases where we've actually seen women take it up.
All right. Thank you, dear colleagues, and thank you, Juan. Can we have a report back from Group 2 on impact-conscious lawmaking? Thank you. It's Nolwand Lemadi is going to do so.
Thank you, Prof. I think with Group 2, because it might seem that it a bit out with customary law, if I can just maybe introduce it, that the group that was presenting today is we're working together to on exactly the topic of this plenary session, which is impact conscious lawmaking. Can social justice assessment instruments make a difference? And what our keynote address started by saying was, does customary law have a place in our modern constitutional democracy? So that's where we started with our discussion. And we went on to look whether that, because our project that we're working on has introduced an impact assessment matrix to assess the impact of policy and its consequence on various groups, that it doesn't have unintended consequences and increase inequality and poverty in our society, but rather reduce that. So the social justice in this case will equal substantive equality, and so our keynote address went on, keynote speaker rather, sorry, went on to say transforming customary law is it is important so that everybody is recognized in our society, as we heard from the previous group, that people in customary marriages feel unrecognized. So this is where we're coming from when we're checking for impact. Then we spoke, then we had our engineer. We had a very good group of a very diverse group of people. We had an engineer, we had a data scientist, and we had a water specialist and a law professor. So our engineer spoke from the point of view of technology. When technology is introduced in an industry, for example, if a company wants to introduce a certain technology, they make decisions based on what they want to achieve, not on what that technology may do, the unintended consequence of that technology. They do not look at how, for example, how the training sometimes, I mean, probably they do in places, things like training required, and how it's going to impact people different. It's not one size fits all. And also what they don't look at is actually the organization itself, the viability of this technology within the organization, and the employees, their satisfaction, how they are impacted by the technology and by the work they're doing. So he went on to say, because we're working then on this tool to assess like impact of policy making, that embracing the humanity of everyone, whether you are in industry, whether you are government, and when you're making decisions, you need to embrace the human everyone. That's where Ubuntu comes in. That's what we've been talking about the whole day today. And so this instrument we're looking we're developing, it seeks to educate at policy level. So it will be in parliament, it will be at education and academic level. We also want to see it in schools so that everybody starts having this conversation about policy making, about the impact of policy on and how that works to bring about an equal society. And so also, yeah, those conversations will be important to inform where we're going, where we want to be, and not just have one size fits all. And what is the role of data in all of this predictive data? Because it can be for good or bad. I mean, it's got its advantages and disadvantages, because while data will help us make more informed policies, it also might be biased. Data can have bias, especially when historical data is used. So that's why in our project, we are collecting data in real time, disaggregated data at ward level. We're starting with one municipality where we're collecting data to test this impact, the impact of policy, that especially now we're using COVID-19 as a real time everything. I mean, we've all become, we epidemiologists, we doctors, we've got so much knowledge that we vaccine specialists. That's the information, the amount of information that we're bombarded with on daily basis on our social media, on news, everywhere we go, church. There's nowhere where we're not talking about COVID-19. So we're seeing this where and there are so many regulations. We talk about this, what do we call them? The family meetings that when we have them, but we also talk about the impact of each regulation. And that's what we want that government to have regulation, and then the impact, they only realize the impact of it later down the line when children have missed school, for example, because of online learning, when the informal sector traders have lost business because of lockdown regulations. So this is what we're trying to do here, that government has, they first test the efficacy of policy in a virtual space before they can see if it will work in real life, and that so that they don't cause undue harm to those people they seek to protect. Thank you.
Thank you so much, Nalondle. It's just wonderful that you stepped into this, whereas the person who was supposed to do it was not there. We appreciate it. Is there anybody from the group who wants to add something?
I think other than you, Prof, Prof. Bofu and Prof. Kanshu have, unfortunately, they apologized and said they had to leave.
All right. Everyone else has gone except Dr. Mshai was in the room. Dr. Mshai, anything you want to add? No, if there's nothing, thank you, Doc. Any questions that would like to ask Ms. Made? All right. It was an interesting conversation about the dangers of using data analytics, in that you still have to teach the machine how to think, and you teach it by feeding the data that you want it to use as a basis for predicting what's going to happen in the future, and that data can be outdated and that data can be biased, which means the use of algorithms to predict the future could exacerbate inequality. And I think our colleagues from the data science, Prof. Kanshu, answered the question, yes, we must use data analytics, but we have to be careful about the dangers. Thank you, dear colleagues. Let's hear from the that was discussing human rights dimensions of Ugutwala and other girls' rights issues, including finding spaces to move the needle on gender-based violence and other gender challenges in traditional communities. Right. Can we have the GBV group? Yes.
I'll be reporting back for my group. First of all, can I just say that we had some incredibly profound levels of insight from Advert Malaleko, of course, is the DG women, children and people with disability, as well as some really brilliant insights from the academic, the women in this space who are doing really important research in both a qualitative and quantitative sense. Obviously, there are huge dimensions of trying to define exactly what Ugutwala is, where it emanates from. A number of the speakers pointed out that this was a practice that is not something that is a modern phenomena. It was something that was situated in certain practices many, many years ago. But there are misunderstandings about what it means and the fundamental kind of abuses that are wrought on young women through this, as well as misunderstandings and abuses of lobola. The pivotal issue here, which came through in all the speakers who were talking, was that social inequality and poverty make young women much more vulnerable to forced marriage and forced rape, particularly at young ages where they are legally unable to consent to things like marriage and to forced rape and sexual intercourse. I think what was one of the most profound things was also that the research of a number of the kind of groundbreaking things that were done were really about giving voices not only to the young women who are experiencing this now, but to the older women who had experienced it as children and carried a lot of the embedded trauma with them about what had actually happened. And this importance of approaching this not only from a policy level where government implements policy to protect women and girls, but also on a social empathetic level where those that older women carry about with them are actually systemically addressed, and they are asked, and able to articulate and that is given a voice to. That there needs to be a dialogue, conversation with communities about these practices, which very often are seen by the families that consent to them as being intrinsic to survival of the girl child and to survival of the girl child's family. So they see it, also with HIV/AIDS stats a few years ago, that the statistics around teenage girls with HIV infection as a consequence of unprotected sex are massively high. And that speaks to, I think the DG actually spoke about it, the so-called blesser phenomenon, where young women are involved in relationships with much older men as a mechanism of social and economic survival, often with the consent and knowledge and of their family, in order for the family to survive. Certainly in terms of some of the reporting that I've done, we've had scenarios where I've spoken to young women who've said that they embark in these relationships because, for instance, they can't afford sanitary towels and things like that. And so this is a pivotal issue for their economic survival. So it's not just, and it's also, the knock-on effects of things like ukutwala and, abuse of young women, which we see so well documented, for example, in the statistics that recently came up, I think about 23,000 young girls in Johannesburg being pregnant, some as young as 10, is that, it's how absolutely limiting these practices are on the lives of young children. That kids children that are taken out of school so that they can be wives, or fall pregnant at a very young age and are removed from an educational opportunity or possibility, are not likely to get out of that poverty that is so damaging to Black women. I think, Prof, you've actually said it, that the face of poverty in South Africa is Black and female. And that is one of the pivotal drivers behind why, women or young girls find themselves forced into abusive or sexually exploitative, I don't even want to use the term relationships, but situations, because they need to survive it, and then they can't get out, because what kind of future do they have outside of these scenarios? How will they survive? How will they get food? How will their family survive? So it's about approaching it with an understanding that education should be a pivot factor for young women having a sustainable and economically beneficial life for themselves. And that, like sexually exploitative relationships are not the only mechanism that exists for them coming out of it, but also that crucial importance of women being able to tell their stories, deal with their trauma, and getting buy-in from the communities themselves, in which these practices happen. That this is not a positive and societally beneficial practice that is going ahead. And I think that, I really appreciated the fact that the research that was done was very broad, gave the statistics, the general patterns where this is occurring, in specific areas, but also, that the researchers themselves, who are all women, who are all looking at this practice and trying to understand why it is still prevalent in a constitutional democracy, which seemingly prefaces the rights of all people, the constitutional rights, bodily integrity, right to education, etc., that they had such a deeply empathetic approach. And I mean, one of the stories that, was brought up was, an older woman talking about how she had been raped with her husband's family standing outside and listening. And, the way in which the ownership, that there's been a normalization of women not belonging to themselves, not being seen as having agency, and particularly women who are in economically vulnerable positions being seen as almost pawns that are moved around according to the wishes of their families or the men who embark on these abusive relationships. So yes, it is a story of social inequality. It's a story about denial of opportunity, but fundamentally it's also a story of how we start shifting, the attitudes of certain groupings within society that this is normal, that this is okay, and start prefacing women as having agency and ability of their own to make choices and pursue their own futures and education in a way that is supportive and ultimately beneficial to the entire society and its economic survival. Thank you.
Thank you. Thank you, Karen. It's so good to see that you look well. And then again, I'm going to ask if, well, I'm saying this to people, Karen was affected by COVID-19, and that's why it's so pleasing to see you and looking so well, exceptionally well. Colleagues, is there somebody from the group that would like to add something that Karen Moon might have missed? Is there anybody? Okay, if there's nobody from the group, again, is there any question to Karen Moon or this group on GBV? Right, we seem to have exhausted everything on gender-based violence and Ugutwala. Unfortunately, it was an area that was also dealt with extensively by Inkosi Pathelomisa. Right, we're looking forward to getting hold of your documents. Okay, Rahadi Priska, please take the floor for a minute, ma'am.
Okay, thank you. Can you hear me?
Yes, ma'am.
Okay, I just wanted to ask Karen, and this is really something that I've thought of for many years, because for people who investigate, who research, there's a tendency to only understand particular cultures. As a white woman, I really want to be direct with Karen. Are you ever going to research the same kind of gender-based violence issues that really affect South Africa amongst the white population? Because it will really help us when we develop programs to know the magnitude of this. And I really have heard answers from people who say, oh, because Black people are a majority. But a single death of a single woman, Black or white, it's very critical for us to be able to deal with this program. But I want to ask you as a white woman, will there be a time? Yeah, thank you.
Thank you, Rahadi. Just before Karen answers, I do want to frame the conversation that Karen was not the speaker. She was the facilitator. The person who presented was Advocate Joyce Maluleke, who has researched the issue of GBV in all societies. And obviously this conference is focusing on customary law, and obviously the focus will by default be more primarily on Black people. I just wanted to indicate that so that Karen doesn't feel like she is being made to.
Oh, no, I don't feel that. I think it's a very fair question. I think
sure,
it is
Prof.
a very
Can I also just qualify what Prof's comment is?
Yeah.
Right, but don't worry, Rakadi, let Karen answer your question so that we can move, ma'am. Just consent.
No, I know you. Listen, I think it's a very fair question. I spent a huge amount of time in my formative years at the Cape High Court documenting intimate femicide, and I've done a lot, for example, on the Susan Roder case, which is in the SCA, where the accused in that case is a very wealthy white man, and obviously has attempted to claim in a defense that his wife actually killed herself. And I see, you know, in sort of privileged echelons of society, replications of the same kind of levels, like denials that occur in a lot of others. For example, with typical intimate femicide cases, men, you know, and this is across the board, will typically say that they can't remember what they did. They just lost their temper. Next minute, they're standing over this woman and she's covered in blood and dead. And they like just lost their emotion. And that is a typical stance that is adopted in many of these intimate femicide cases where men refuse to take accountability. And I've seen, especially in rape matters as well, there is a refusal to take responsibility for the fact that you have exerted yourself upon the autonomy of a woman, whether that woman is in a privileged space in society or whether she is very poor. But you know, I do see a very fundamental problematic, you know, discursive problem in terms of prefacing, you know, the trauma of, for instance, privileged women is given a far more greater airtime and airplay than the privilege of marginalized Black women. And I think that, you know, that sense in which voices are important, that women need to be given the spaces to articulate these stories are pivotal. But I think your criticism is correct. We have huge rates of intimate femicide in this country. We have huge rates of rape. Those exist across all echelons of society. And as someone who, as a child, survived sexual violence, I certainly am aware that, you know, this is not something that just occurs within specific communities. It is something that is endemic, and it's spread across all, you know, race groups, all levels of society. It's very, very damaging. And that's why we need to talk about it openly, honestly, and put the voices of victims forward so that this can be dealt with. So thank you.
Thank you, Karen. That was very gracious. And thank you, Rakadi, for the question. Can we now then have the final group, which is going to be group 4, equality and succession, inheritance, challenges in traditional leadership and the family. The rapporteur, it's not indicated here who's the rapporteur. However, the keynote there was Judge Ndita. Can we have the rapporteur on this issue of succession and inheritance?
Thank you, Prof. It will be myself. I'm Letabo. I'm going to try and recapture and highlight to you what was discussed in that plenary session. I'm going to start with Judge Ndita. She spoke of the rights of women and her own experience and how she has seen the legal protection of women's rights evolve throughout years. She spoke of the milestone in Bear and others versus Khayelitsha and others, which opened the door to the vindication of the right to equality in the customary law of succession. She spoke about some of the disadvantages where women are forcibly removed from their lands because of the lack of a male voice. But obviously, as I've already highlighted, the Bear and the Bear versus magistrate of Khayelitsha addressed that. And then she now spoke of the patriarchal practices that persist even till today. Then from there, we had the CGE that basically highlighted some of the undertakings that they are leading. They spoke about the situation involving the Ingonyama Trust, where women are not allowed to own land without the voice of a man. And obviously this speaks to the concerns raised by Judge Ndita of women needing a male voice in owning their own land. And then we had the next speaker who was speaking of the analysis of the impact of the South African Constitution on the recognition of Islamic marriages for the purposes of interstate succession law. The speaker, to show their plea, spoke of the timeline, which spans over 300 years, and with over 750,000 Muslim people seeking and pleading for the recognition. And he also spoke about the possibilities for change which lie under Section 15, subsection 3 of the Constitution. And obviously, he spoke about the right to freedom of attestation, that is according to the Islamic laws. And then as another way to AVA, to actually avoid the disadvantage of women. Right, one another way he spoke about the gifting during marriage, and then this could be challenged through in the constitutional democracy based on other constitutional principles. The third one that was addressed was on the cultural influences and practices of inequality in the customary law of succession and inheritance in South Africa. While Bear is the milestone, but the male primogeniture continues in the practice in the African family structures, where seniority is based on the hierarchical structures in the family, which are also patriarchal, where the male elder of the family stands to be the one who will inherit the family property. This resistance or lack of deviation of the male primogeniture has led to family businesses in the rural communities to fail. And obviously, we can now see that the Somalians and the Pakistanis have actually adopted and perfected the business model of rural townships, plaza shops, and supermarkets. And then this development has led to some families, in order to have some income, they resorted to renting out the shops in order to sustain themselves. And the lack of deviation of the male primogeniture in the customary interstate law of succession has also led to bigger challenges of poverty, inequality, separate development, diminished family ties, where younglings who do not stand to inherit, migrate, and develop skills to achieve some independence and sense of leadership and dignity away from the family. And furthermore, it has led to the insider-outsider principles, where family members become oppositions to one another, resulting in sibling feuding and sabotage as the way of rebelling against the inequality. The reform requires Section 2 and Section 5 of the Reform of Customary Law of Succession, Regulation of Related Matters Act 11 of 2009. The conclusion, based on the debates after the presentation, was that there should not be a disjuncture between policy and advocacy, and more awareness is needed on the negative practices infringe on equality, and sessions of this nature need to be increased to achieve a change in policy. Thank you, Prof.
Thank you, dear colleagues. That was Letabo Tlobata reporting on issues of succession under customary law for chieftaincy rights and inheritance in the family. Are there people from the group that would like to add anything? Anybody? All right. Any questions that you have for this group? Right. In the absence of questions, I have 4 minutes to summarize the proceedings of today. Just firstly to say thank you to all of you who took your time to be part of this extremely important conversation. We talk about Nancy Fraser's key anchors of social justice being recognition, which means I see you, I understand and appreciate you, you're part of humanity. The second one being representation, being given voice in decision making, and thirdly, restitution. And this is one group, those who are affected by customary law, that find themselves particularly excluded when it comes to recognition, representation, and restitution. So I'm very grateful that you took your time to come and champion this conversation on customary law. Grateful to the Minister of Justice to come and set the record straight on the vision of the Department of Justice when it comes to customary law and the department's intentions with regard to using transformative constitutionalism in legislation design. I also thank the Deputy Minister of Justice and a member of traditional leaders of the Traditional Leaders Council for coming to present their view of traditional leaders. The two justices in the room, Justice Nguki and Justice Dita, we thank you too for coming in and giving us a view of the judiciary. We thank the academics in the room, so many professors from law, from data science, engineering, and all other areas for coming together and sharing your views. But more importantly, also grateful for those from civil society that came into this room and presented us with a view of the people. Today, basically, we have heard people accepting that transformative constitutionalism is an injunction of the South African Constitution and the Kenyan Constitution, and that a component of this injunction to use the Constitution to transform relations in society, systems in society, processes in society, and culture in society is social justice, which at the social justice chair we regard as fairness to all in its simplest sense, but in a more robust sense, we regard it as justice. Moseneke said it's the same as substantive equality, which is embracing the humanity of everyone and ensuring equal enjoyment of all rights and freedoms by everyone, which would be reflected in a just, equitable, and fair distribution of all opportunities, resources, privileges, benefits, and constraints in a society and between societies, or rather burdens in a society and between societies. That's our understanding of social justice, and we believe it's an injunction from the Constitution, and we get that, as we said during the conference, that has been confirmed by cases such as S versus Makwanyane, Minister of Finance versus Van Heerden, and many other cases. We heard that this constitutional injunction is the same for South Africa and Kenya because of the similarities of the constitutions. We heard that courts both in South Africa and Kenya have been in the forefront of advancing social justice, particularly gender justice in customary law. And many cases were cited both from Kenya and South Africa. In South Africa, cases such as Bay, Moseneke, Nyamita, or Shiluba case, etc. And these cases have touched areas such as family law, succession, land, children's rights, and gender-based violence. We heard, though, that the success has been limited and it's been constrained primarily by the fact that the paradigm tends to be colonial. There's still a default paradigm of viewing customary law as a suspect system coming from those colonial clauses that viewed customary law as a repugnant legal system, or as a legal system with repugnant provisions. And this has been seen in how, for example, the courts, we heard from Advocate Ngugai Tobi, have dealt with land rights, concluding that under customary law, there is no ownership. In my presentation, I also indicated that has also explained why, instead of developing customary law in some of those cases, such as Moseneke, we simply superimposed common law and with unjust consequences. There was also a major concern that these changes, or the transformative constitutionalism, has not dealt with cultural practices that despite changes in the law, remain and keep women as subhuman beings in terms of GBV, in terms of marriage, in terms of widowhood, and many other cultural practices. We heard, though, that things are changing both in Kenya and South Africa. And the South African landmark case that was cited for us was the Ingwenyama Trust case, where the Constitutional Court deviated or broke away from the treatment of customary law as repugnant, the tendency to fossilize customary law, the tendency to homogenize customary law, and the tendency to distort customary law. And in this particular case, a decision was made that customary law does not allow a traditional leader to superimpose himself or herself as a trustee and then make the residents tenants and charging them accordingly. And this was upheld as a landmark case that is showing that customary law is dynamic, it need not be fossilized, and also it is a system that is anchored in communality, in the interconnectedness of humanity, and ensuring that everyone is looked after. We proceeded to go into the breakaway groups, where the discussions were on 4 key areas. The one group was discussing issues such as Utwala, GBV, etc. The one was discussing gender equality in marriage and other areas. One was discussing impact conscious policy making, and then the other group was dealing with challenges in addressing ukutwala and gender-based violence. All of these groups came back with the understanding that we have made progress in advancing equality and human rights under customary law through using transformative constitutionalism, but there are gaps. And the conclusion was that we need to consider restating customary law, and that the conversation around how do we restate customary law, particularly in areas such as marriage, where a lot of people are stuck in a situation where they don't know whether they're married or not, and similar questions are arising when it comes to land rights and succession. The conclusion is that the conversation should proceed, and hopefully we could have a reading room that proceeds with discussing these developments under customary law and looking at the court cases that have moved the needle, and in considering how that could be translated into law. The Green Paper on Marriage in the Department of Home Affairs was mentioned as one avenue that is an option for engaging, where we could engage on a possible uniform, on a possible integrated marriage system, but which understands and accepts diversity. And in so doing, issues such as, for example, gay marriages under customary law would also be incorporated, because currently those are some of the fault lines in terms of how the Recognition of Customary Marriages Act is interpreted. Dear colleagues, we will then be coming back to you with the results of these proceedings of today. We will be giving you the videos, later a written report, and then inviting you, if you want to be part of this reading room that is continuously looking at how do we make sure that people living under customary law do not have a life that is more difficult than the rest of us. And if they do want to be governed by customary law, the system does not force them out of being governed under customary law. They are given the same rights, the same recognition, the same opportunities, and the same privileges as everyone else. And that common law and customary law get treated as laws that both need transformative constitutionalism without one of them being regarded as delinquent or repugnant. Thank you, dear colleagues. May God continue to bless you. And thank you to the team that organized this event, Marna Lawrence, who was the head of the coordinating team, Diane Kahiza, who supported Emil Fekel, who was a part of the coordinating team, Nolwandle Made, who assisted. And thank you to the tech team that has been behind this fabulously and painlessly facilitated digital dialogue. Thank you, everyone. Blessings. Stay safe. Hi, I don't get my leg. What a joy. What a joy. We should talk. Yes. Hi. Thank you.